Thank you so much, Dan. And I want to thank the Dean and the Law Review and Dan Medwed for organizing this wonderful symposium and inviting me here. And I think I should start by addressing what Dan just said about how we had never heard of him. In fact, when I started researching for this paper and rereading many of Dan's wonderful articles, it struck me, I don't really know why Dan is having this conference, since he seems to have single-handedly already said everything there is to say about this subject. But I hope that I can bring an additional perspective. What I want to talk about actually also follows from what Dan just discussed in part about popular culture and popular perceptions, and that is, what do we mean by this category, wrongful convictions? Is this a helpful category, and will it remain a helpful category now, as Dan just said, we are moving beyond the DNA exonerations into more uncharted and ambiguous territory? So I want to talk about that, and I actually take as my starting point a very interesting op-ed that appeared in the New York Times not too long ago by a sociologist, and what he argued was that because the majority of those exonerated for capital crimes are on death row because of intentional and even malicious government conduct, we should no longer use the term wrongful convictions, we should use the term unlawful convictions. Personally, I don't see that much of a difference, but the argument is interesting. He says what we need to do is we need to incorporate in this term some kind of recognition of the prevalence of dishonest and downright illegal behavior by police and prosecutors in capital cases. And we should begin by calling the conduct by its rightful name. So this got me thinking, first of all, about, my first reaction was, why does he care so much about the labels? You know, why is that what we should be talking about? But of course, I thought about it a little more, and I thought, well, of course, with abortion and other divisive issues, the battle over nomenclature has been a central aspect of the dialogue, and that has certainly been true in capital punishment as well. The category of innocence, as we well know, is hotly contested terrain. What is meant by found innocence when, as we know, this is not a term that jives with the legal standard of not guilty. What category of people are we describing when we talk about people who have been exonerated? So this category is contested from both sides, right? It's contested by death penalty supporters arguing that the system generally works, and that claims of a fallible capital justice system are exaggerated. And it's also contested by death penalty opponents arguing about whether the innocence movement has had a harmful effect on broader efforts to reform the capital system. So that's certainly true. What this author is getting at is another part of the category, another part of the label, which is the fact that the term wrongful contains a judgment not just about the defendant's actions and who should be part of the defendant category, but about the government's actions. And he believes that calling the conduct unlawful would be both more accurate and more strategically effective. And I have doubts about both these claims, as I will discuss. First of all, I'm not at all sure that labels about intent and malice more accurately describe what's going on here on the state side, on the government side. In addition, I want to suggest that they may backfire strategically, that sometimes when you start labeling people dishonest or malicious, it becomes so radioactive that the attempt to avoid applying the label ends up protecting bad behavior rather than preventing it. So what I want to do in the next few minutes then is address my remarks to the fraught terms of this debate about the content of the category wrongful convictions. And I don't have to go through again what Dan just so well summarized about how basically what we've seen here is, I think, the most successful death penalty reform movement, certainly in our lifetimes, and some of us have much longer lifetimes than a lot of you do. These stories of innocence have had a visceral effect. They moved and energized people in a way that empirical data never could have done. And yet we have an enormous amount of work left to do. And I think it would be dispiriting to think that the movement, the successful movement, drew all its power only from revulsion at the execution of those who can prove themselves blameless. I think that part of the bitter contest over how we define the terms is about how we define injustice. I also think there's an immediate pragmatic question. To what extent does it remain helpful to organize our thinking about injustice in capital cases around this notion of wrongful convictions? And also, if we do continue to use this category, what can we learn from the successes so far? And why has this concept had so much power, and can we continue to harness this power as we move into this more uncharted territory? Okay, so let me talk first a little about the innocent defendant and then about the government conduct. Concepts like innocence, exonerated, and wrongfully convicted are often used interchangeably. I want to suggest that the stunning and virtually unprecedented reaction to these exoneration cases that Dan was just talking about was keyed to a very specific notion of innocence, which Carol and Jordan Steiker from Harvard and Texas have suggested this also, was not so much a legal concept as a moral one. It kind of evokes the idea of unjustly treating the blameless, as opposed to just the legally innocent. I think that part of the lure of what we had here, or have here, is the simplicity and clarity, the promise of a clear line between the undeserving and the deserving. We're talking about vivid stories where the injustice is very easy to understand at an emotional level. Then we couple that with the authoritative ring of DNA evidence, and that's what gives the stories their tremendous power. This is a power that works on a number of levels. Most basically, for most of us, for all of us, simple categories are reassuring. They seem to absolve us of this difficult job of sifting facts, evaluating competing perspectives, and making value judgments. So a notion of innocence that boils down to either he did it or he didn't do it is attractive because it seems factually and morally unambiguous. This is a preference that's very much exacerbated by the media. So most people have little direct contact with the criminal justice system. Most people get most of their information about crime, and particularly capital crime, from the media, and they don't necessarily distinguish, as the studies show, between news shows, reality shows like Cops, or fictional shows like Law and Order, which then complicate things, by the way, by basing themselves on recent cases. Most people see all of this as kind of a seamless torrent of either information or misinformation, and they kind of imbibe it to get their sense of what's going on. And if you think about a lot of these cases, mostly they tend to reinforce this split between the morally and factually blameless and the guilty as sin. Very rarely do you walk out of one of these shows with open questions about who committed a crime or about whether a homicide amounted to a murder or manslaughter or about what the proper sentence should be. So the advent of DNA has really fed into this belief, into a clear ascertainable split. It's basically viewed as an on-off switch, an either-or test, kind of like a pregnancy test. You either are pregnant or you're not, and the stick will turn red if you are and green if you're not. I don't know if I have my colors right, but that's the basic idea. This is not to minimize the importance of DNA, which I do not want to do. It has saved lives. It has set prisoners free. It's been crucial also in demonstrating even to the most skeptical observers how often suspects are actually wrongly convicted and wrongly sentenced. The worry is that a lot of its public appeal derives from its resonance with the public's need to believe that there's an ascertainable test for telling truth from lies and good from evil. Kind of like the newest thing on the horizon, the no-lie MRI, which we could talk about later if we want to. The concern here is with this false promise of moral clarity and scientific infallibility. It's easy to identify with good people who have done nothing wrong and who are sucked into nightmare situations. But what about good people who've done something wrong, but not something that amounts to first-degree murder, or those who committed just an ordinary murder, of the sort that only elicits a capital sentence when the defendant is poor, black, and incompetently represented, or those who have been in trouble before but done nothing wrong on this occasion. And I was just talking to the other panelists about Stephen Avery in Wisconsin, who was one of the exonerated. He was exonerated for murder based on DNA evidence. Then he went out and committed a murder. And the fallout was tremendous. I mean, the emotional fallout. But Dan was just agreeing with me that it couldn't be that people now really thought that he had committed the first crime because it was a single perpetrator crime and the DNA cleared him. So it's more like He's the kind of guy who could commit a crime like that. He's not the kind of guy that we think of when we think of people who are exonerated. So these are the hard ones. The challenge is to make people angry at a broader spectrum of injustice and to make them angry enough to take action. And that's not going to happen just with information. Information isn't enough. What we need is information that's not merely convincing, not merely intellectually troubling, but emotionally infuriating. And as any good capital defense lawyer knows, it's possible to tell a story that creates empathy for flawed human beings. It's possible for people to understand complex motives. It's possible for people to care about those who are accused of and even convicted of heinous crimes. A good lawyer, with the right presentation of mitigation evidence, can help jurors put themselves in the shoes of the defendant, even a defendant they have just convicted of a heinous crime. But that's a painstaking and individualized process. It's difficult to tell a penalty phase jury a complex story about a flawed human being who committed a crime but may not deserve to die. It's even more difficult to educate the public about systemic problems that are going to continue to produce miscarriages of justice. And it's most difficult of all to get them to move to action, to really care. And that's what I want to move to now, is this issue of how we think about the government's role here and how we think about the injustice. So the innocence cases worked, the innocence movement worked, because it showcased a systemic breakdown that the public found shocking. Stories like those of the Ford Heights Four, who barely avoided wrongfully being executed, largely through the efforts of a group of journalism students from Northwestern in my town of Chicago, highlighted the reality that sometimes the system does not correct its own errors in capital cases. What worked here was that the innocence movement succeeded in linking these stories into a narrative of dysfunction. Not just a few isolated mistakes, but something systemic. What are the contours of that narrative? How far can we push it? To what extent can it be extended without losing its power? I think that's the challenge that's facing us now. As Dan mentioned, one challenge is to convey the continuing nature of the crisis. DNA cannot be viewed as the cure-all for this particular disease. It's not a panacea. It only exists in certain types of cases. It's subject to human fallibilities itself. The larger problem is with creating reforms that are targeted not wholly toward the innocent. And I think we can talk more specifically about that later. The notion of fair process, as distinguished from the notion of fair results, is a hard sell. The notion of process is an abstract notion. It's not very media friendly. The notion that a process that's needed to protect the innocent will unavoidably also protect the guilty is a sophisticated notion. An even harder sell is the idea that all suspects and even convicted defendants should receive fair process, not just as a windfall, but because our protections are meant to protect not only the innocent, whatever it is George Thomas might try to tell you later. There are stories that can be told to illustrate these points, but they lack the clear moral and the obvious good guys and bad guys that have enabled the innocent stories to reach across ideological lines. How do you convey the importance of process? It's really hard. One remarkable narrative conveying the gradual understanding of the importance of process is the story told by former Illinois Governor George Ryan when he announced his decisions to pardon 4 death row inmates and commute the sentences of all the rest to life without parole. And for those of you who have been following his story, I should note that former Governor Ryan's own story is also a lesson in the complexities of human behavior. Ryan begins his speech, which I commend to all of you. He gave 2 speeches, one at DePaul and one at Northwestern, for the commutations and the pardons. He begins by locating himself as a law and order conservative from a small town in Illinois, someone who never gave much thought to the workings of the criminal justice system, except to assume that it worked just fine. The evidence of wrongfully convicted defendants started to accrue until they constituted the majority of those on death row in Illinois. He describes what happens when it hit him, that there was this broken system, that no other official was going to fix it, and that it was actually his problem, that if he didn't act, nobody else would. What's remarkable is his description of his realization that this was more than just a string of individual injustices, and that he could not fix it solely by individual pardons. The system was so deeply broken that he could no longer trust its results in any of the cases. One incredibly moving point in the story is his description of the murder of a friend of his in his hometown of Kankakee, and his realization that even the man who committed this particularly heinous murder, whom he had no reason to think was wrongfully convicted, would have to be spared the death penalty because the system was broken. His story illustrates his visceral understanding that there was a connection between the individual stories of injustice and the broader story of systemic dysfunction. It ceased to sound like a lawyer's argument to him. It became something he understood not just intellectually, but emotionally and morally. And that's what has to happen. How much time do I have left, Dan, you think?
Well, I'm not enough.
Just enough? All right, that's perfect. Thank you. I'm not going to take that much more, but I want to talk finally then, my last set of remarks is about how we frame government wrongdoing in light of these issues. So how do we do that in order to motivate reform? Remember, I began by talking about the author of this op-ed, who said we should frame government wrongdoing in a way that highlights the malicious or intentional aspects of it. This brings me back to my initial question. What's the value of naming and labeling? What purpose do we serve by creating this category of wrongful convictions? And what are the dangers we want to avoid when we create that category? I suspect and I assume that the goal here is to identify and call attention to a common set of problems that lead to injustice so we can solve those problems. I want to suggest that using bad faith as the central explanatory frame for the systemic problems that lead to wrongful convictions has a couple of big problems with it. First of all, even where intentional misconduct seems provable, the decision to label it as such might be counterproductive. And second, the more we learn about decision-making in institutional contexts, the less helpful terms like intent and bad faith appear in figuring out what needs to be remedied. A couple of reasons about why it might be counterproductive. Stories about bad guys, malevolent villains, like stories about blameless victims, pack the greatest punch. And when government misconduct is at issue, these stories play a very powerful role. What they do is they depict the wrongdoers as rotten apples in an otherwise pristine barrel, as a few isolated rogue bad guys. This pattern of blaming and even demonizing individual government actors is very deeply ingrained. You can think about Brownie at FEMA during Katrina, for example. But it's especially noticeable when law enforcement wrongdoing is at issue. The torture at Abu Ghraib has been trivialized, both in its public portrayals and in the patterns of prosecution, as the work of a few rogue evildoers and their compliant, naive girlfriends. The actions of Mike Nifong in the Duke Lacrosse prosecution have been decried without, thus far, a sufficiently hard look at the system in which his conduct was allowed to proceed unchecked. I can give you many more examples, including some from a police torture ring in Chicago that I've written about. But in such situations, the government's desire to force blame downward towards street-level actors happens to coincide with the public's own needs, because it's very hard for the public, and the courts incidentally, to accept systemic wrongdoing by those we trust to protect us. And we have many ways of warding off that knowledge. This story of a few bad apples is convenient for policymakers, and it's comforting for those who need to believe that the world is just and that the government is benign. Systemic misconduct by the government is a hard story to tell. It's not uncomplicated. It doesn't necessarily involve malevolence. It involves complex chains of command, multiple actors, failures to act instead of action sometimes, actions that are taken in good faith rather than with malicious intent. It can't be neatly resolved by punishing the bad guys. And as I've mentioned, to the contrary, punishing the most obvious bad guys when that's the end of the story might mean leaving the deeper sources of the problem unaddressed. In addition, calling attention to bad faith might backfire. The incendiary nature of claims of police and prosecutorial bad faith really raises a very difficult conundrum. I find it a conundrum because I've been writing for all my life, and before that I was a lawyer for the ACLU. I spent a whole lot of time worrying about government accountability and bringing people to account for their bad acts, and I certainly don't want to stand up here and say that's not important. But we're thinking about what's going to work and achieve the goals that we want. Sometimes strong condemnation of misconduct is absolutely essential. But sometimes condemnation of individual actors takes the place of the broader examination that I referred to. But in addition, sometimes condemnation itself becomes the focal point. All the energy gets drawn toward arguing about what the level of intent was, whether this is the right label for it, and we do that instead of focusing on how we can fix the problems. So how do you frame the debate so the spotlight stays trained on essential information and doesn't devolve into a diversionary argument about labels? That's the challenge. And finally, my last point. The bad faith label might not accurately capture what really goes wrong in most cases. Some cases, yes. Many of the problems that lead to wrongful convictions arise not from identifiable individual intentions, but from incentive structures that are deeply embedded in police and prosecutorial culture, and that are, of course, exacerbated by political pressures and other external sources. Recent work on cognitive processing helps explain how police and prosecutors can take actions that lead to or protect wrongful convictions without exactly knowing that they're doing so. A lot of people, myself included, have written about, and Dan included, have written about the problem of prosecutorial tunnel vision, which involves a mostly subconscious refusal to consider or reconsider information that contradicts an initial theory of the case. These cognitive biases are not going to fit into legal definitions of malice or intent in most cases, and they are rarely the stuff of riveting accounts of bad behavior. Ironically, categorizing conduct as blameworthy might also have a perverse effect at this level. People will go to great lengths, we all do this, to avoid thinking of themselves as the kind of people who would do such bad things. What does this lead to? It doesn't mean they're going to avoid the behavior. It means they're going to avoid facing the unethical nature of the behavior or the harmful consequences of the behavior, thereby entrenching it and insulating it from correction. Okay, so to conclude then, it would be an egregious error to assume that these biases cannot be addressed. On the contrary, the more we understand about how the behavior works, the better we can structure the institutions to correct these biases. We might want layers of review. We might want mandated exposure to contrary theories. We might want different incentive structures. So I would suspect that if assistant prosecutors discovered that wrongful convictions caused them to lose opportunities at promotion or salary increase, or to lose the respect of their colleagues and the support of their superiors, they might themselves begin seeking out ways to counteract the possibility of tunnel vision. Or if elected prosecutors found that wrongful convictions made them less electable or subjected them to sanctions or litigation, they might take a hard look at the incentive structure of the office and whether it provides a check on these biases. One way to approach the problem is by beginning with the question of reform rather than the question of conduct. And I think that might be the way to go here. We can start putting checks in place that address error generally. If we can do that, maybe we don't need to discern exactly what level of intent is at stake here. Increased transparency, better training, stronger ethical rules, better enforced ethical rules, checks on discretion, change in culture. These are going to address a broad range of conduct, whether it's mistaken, erroneous, or deliberate. Sometimes deliberate or vindictive conduct will need to be singled out. Sometimes public censure or discipline is the only way to go, but not necessarily in most cases. So the question at hand then is how to learn from the success of the wrongful conviction movement and where to go from here. The goal, I say, is to implement systemic reform, and as we've learned from the wrongful conviction movement and its great success, in order to implement it, we have to find a way to explain it to the general public, and more than that, to explain why it matters, why they should get angry, why they should care. I think our task is to complicate these easy labels, to find ways to communicate concern for more than just the innocent, and to communicate the dangers of conduct that defies traditional definitions of blameworthiness. Thank you.
Thank you.